Yeah, that's exciting.
Yeah, I think I'll maybe he'll show up as a special guest.
That always adds some fun to a webinar. All right. Looks like we have some participants joining us now. Hello, everybody. Thank you.
Hi, welcome everybody.
We will give everybody a few minutes to log on. It's still only 12:59. Maybe we'll give till about 1:02 for folks to log on, but appreciate all of you guys joining us today.
But that's how excited we were. We said, let's start it 1 minute early. Just, I can't wait. I want this to be 1 minute longer than it's supposed to be.
We tried to wait, couldn't wait.
Bro?
All right, thank you guys again for continuing to join us. See, we have 57 participants. This is great. We're going to give till about 1:02 to have everybody log on. This is exciting. Thank you. All right, still more people joining. Thank you guys. About 1 more minute and we'll get started here.
Yeah. Coffee looks good. That coffee looks good.
It tastes really good. Though I have to drink black coffee or otherwise, because I drink about 6 cups a day.
6. It's a good amount of coffee.
It's too much. That's why cream and sugar is not an option.
There's no such thing as too much coffee, by the way. That's a rule. I don't know if you know that.
I like that rule.
Yeah, no way.
All right. Still some more people joining. That's great. Will this be available? I see somebody has already asked a question. Will this be available afterwards? I have to sign off to teach a class around 1:30. The answer is yes. We are going to save a copy of this and then send this out, and I believe post it on the Facebook page. So that was from Diana Taggart. So the answer is yes, it will be available. All right, guys. Well, I think we can go ahead and get started. I do appreciate everybody joining us today from the Be Yogi tribe. Today, we are going to be speaking with Cory Sterling from Conscious Counsel. And of course, I'm Joe Fagan. I'm the Director of Strategic Partnerships for Be Yogi for our liability insurance. And again, appreciate all of you guys coming today. Want to talk today about some topics that I think is very meaningful to the audience, to the industry, as we are, all learning a new way to operate. We're learning on what it's like to operate under a pandemic. We're learning how to operate coming out of a pandemic, and Cory is going to help us answer some of these questions. So if you don't mind, let me give you a little bit of information about Cory before we jump in here. If you don't mind, Cory. So Cory is he's the founder of a heart-leading firm called Conscious Counsel. He's a lawyer, Cory's a yoga teacher, and he's an actual real human. Imagine that. He wrote the Yoga Law book, and he's served hundreds of health and wellness practitioners, including fitness instructors, yoga instructors, studio business owners, and all around the world. In 2019, Cory won the highest rated session at the Mind Body Bold. And of course, he stays committed every day to teaching about and having fun in law in a practical way. So Cory, thank you for joining us today.
It's a pleasure, Joe. Thank you for having me. Yeah, it's super cool to be chatting with Be Yogi, and I know how much you care about your community and its members, and just this collaboration to provide information to people in a fun and applicable way. It lights me up. I hope that you're excited about today, Joe.
I am. I've been very, having connected with you over the last couple of weeks was very exciting for us. We've been candidly looking for a partner that we could lean on for some legal advice. We have great clients who have questions all the time, and a lot of those questions we can answer through our team of licensed agents. But a lot of time those questions go a little bit beyond our knowledge, and it'd be really nice to have some counsel that could help with that. So this partnership is will be very beneficial to us, we feel like. Thank you.
Cool. And the whole point for all of this is that this is practical information that everyone can apply to their yoga practice, to their yoga business in one way or another. So the first rule about yoga law and practicing law at Conscious Counsel, it's always got to be fun. So what I want everyone to do, anytime I say the word law, I want everyone to say fun. So I can only hear Joe, but everyone who's listening, ready? I'm going to say law, you say fun. Law.
Fun.
Law.
Fun.
There we go. Usually we're doing it in a big room, but Joe, I felt your energy. I felt that come to me. So that really excites me. The past 2.5 months have been totally crazy. Before that, I wrote a book called The Yoga Law Book, and it was like, the same issues with the same clients over and over again. And really what we've seen in the past 2 months have been an acceleration and a magnification of that, where it's like literally everyone who is practicing yoga online, either as a studio owner or as an individual teacher, is going through the same legal issues, and no one really knows where to turn to or how to get clarity on it. So I've just come up with a really quick presentation that I want to share with everyone that hopefully answers each of this. At the end of it, we're going to have a checklist, so a 5-point checklist to sort of make sure that you're at best legal practices with everything that's going on. And we'll make sure that you have a chance to access that or download that as we keep going. So Joe, with your permission, I'm going to get to the first part of sort of like the 5-step roadmap that we've got for everyone to be legally protected during these times.
That's perfect. Yes, Cory, thank you.
Okay, cool. So the first thing that I want to talk about is something that I call the golden rule. And the golden rule in this particular case of all the things the first thing that you need to be aware of is the importance of following municipal and state laws as we're getting to the point of opening our businesses back up. And the reason why this is so important is that there's something at law that's called negligence. And what negligence means basically is like you screwed up and you made a mistake that the average person would not have made. And the average person is just like, okay, they take someone from the street, would that person know that they should or should not be doing this particular activity in this way? And the reason why I'm focusing on the importance of following the municipal and state laws is because we're going to draft great agreements for you. We're going to explain it. We're going to answer the questions. We're going to make sure you understand everything. But it's so important in this uncertain time to show that we are following the rules, basically, right? So wherever you are in North America or the world, you're going to be opening back up, and then your municipality, your state is going to say something like, okay, if you're a yoga studio, you're only allowed 5 people. Or 5 people only permitted in the studio, or people have to be separated by this particular distance, blah, 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 all of the things. As a lawyer, I'm always looking to, it sucks to say, but it's the reality. I'm always looking to the worst case situation, right? So Murphy's Law, everything that could possibly go wrong does. What are the legal documents that we need in place to make sure that you'll be protected, notwithstanding all of these things having happened? And the first and most glaring issue to me of what jumps out is if you are doing something that directly contravenes the laws, the reopening laws of the municipal or the state government, you're a duck in water, it's over. It would be so easy for someone to come up with a claim or to say something against you. Let's say they get injured or something happens or they're offended or this, that, or the other, a violation of rights, right? This, that, or the other. First step first is like, normally we're just following the laws, but in this situation, because there's like the laws are changing all the time and what can we do and how much space and all of these things, we just have to be hyper aware of what those laws are and make sure that we follow them. Because if a municipal government says, okay, you're allowed to open up, but you have to do A, B, and C, and you only do A and B and you don't do C, and someone gets hurt or someone contracts a virus as a result of you not doing C, you're totally going to be at fault and you're going to have been shown to be negligent, which is going to make things more and more difficult. So that's like the general principle. Joe, does that make sense?
It does, and actually, it's it's very salient information, especially for the insurance side too. Insurance is very heavily regulated, so whenever you file a claim, the first thing that an insurance underwriter is going to look at is to make sure everything is legal. Number one, you're legally certified and or licensed to be practicing, what you're, practicing the industry in which you're teaching. And then secondly, just as you mentioned, as you come out of a pandemic, it's going to be very important for them to follow the letters of the law. Again, if you ever go back and try to file a claim or get an underwriter involved, having been legal and following the letter of the law is going to be so important. So it's, again, very salient to our side of the business as well.
Okay, cool. And it's pretty straightforward. And I have clients all over North America, and some of them will write me. They're like, oh, the studio down the street has decided to open up, but they're not following the rules. And firstly, the rule about everything is like focus on yourself, make sure that you're operating at best legal practices and you're following the rules. But secondly, right, if it's possible that your insurance does not apply because you didn't follow these rules, the solution is really simple. Just make sure you follow the rules. So a couple of really practical points that I think everyone can take something away from in speaking about this. And when it comes to following the rules, here are a couple of tips just that I have and that I've worked with my clients for. So one of them is the importance of posting those particular rules publicly in the space of where you are. So let's say, I'm in Brazil County or whatever county I'm in, and they have, these are they have a 3-page printout of all the rules you have to follow. I would print them and I would publicly post them so that other people can see them. And then also it's just it's an added point that if someone's going to claim that you were negligent or you didn't follow it, when people are in the midst of negotiations, or if, someone is presiding over a case and deciding who was right or who was wrong, that's something that really goes to your favor of showing that you were proactive in wanting to deal with something and wanted to address the issue head on. So I would say print out the rules and post them publicly. As well, it's really, really important that you speak with your staff and make sure that your staff understand these rules. And a big portion of the work that I've been doing lately has been updating employment agreements, because, and I'll chat a little bit about that in a bit, but one of the things that I want to focus on is making sure that all of your employees are on the same page when it comes to what rules they have to follow, and you covering your own butt to make sure hey, I told my employees that these were the rules, please review them, we'll have a staff meeting about it, and then you have to apply them. So one tip that I came up with also is if you have a team that's working with you, have a Zoom meeting similar to this, record the Zoom meeting and literally read out the rules that your municipal government is telling you to do. And then in that case, if one of your staff members does something so completely outside, right, doesn't wear a mask or isn't wiping things or this, that, or the other, whatever it is, you at least are showing you were reasonable, you were proactive, you were doing everything that you could to possibly comply. And then just the last thing is just staying abreast of what those rules are. And you could check your local governmental website, to see what they're saying and any updates they're providing. But just basically staying on top of it. And again, everything, and I just to share one really important point about where everything that I'm sharing is coming from. So in about 3 years of operating a yoga law business, I've been hired both by someone who got injured at a yoga studio or a teacher who had a complaint about a boss. I've been hired by those people to either challenge waivers or challenge contractor employee classification. And then I've also been hired by studios to defend a waiver or to defend a particular employee contractor classification. So what I can tell you, the one piece that connects both of them is you're always going to want as many points in your favor as possible. So, and just the practical way that law works, you can throw Tom Cruise out the window or Suits, none of that's the real world. The way that it really works is someone sends someone else a demand letter from their lawyer saying, hey, you really screwed up and I'm going to sue you and this is how much you owe me. And then the other lawyer is going to respond. And at that point, the other lawyer is going to gather information. And for example, if I was the lawyer for a studio, I would say, well, look, we printed all of the information. We had a staff meeting where we recorded it. We made sure we stayed up to date to it. your claim of, and and you signed a waiver of liability to not hold us liable, you have absolutely no case. And like, so yeah, it's I just want everyone to have this perspective about how the law,
Fun.
yes, got there, about how the law
Fun.
operates in a practical way. Because for me, in the in the trenches per se, like every day I'm just responding to demand letters, sending demand letters, drafting agreements, and I see how it really works. And a lot of business yoga professionals don't really understand those nuances. So just so you know, what I want everyone, there's a lot of things I'll chat about, but the big takeaway is like, how can you show that you objectively did as many things as possible to be reasonable? Is that cool?
Yeah, that makes complete sense. And I would add on, I mean, this being such a confusing time, everybody, well, a lot of people have an opinion on what's going on. We all have a kind of a different thought and idea on what's true, what's untrue. In a time of confusion, in a time of uncertainty, I think it exponentially increases the need to follow the letter of the law. When you don't know, the only thing you can control is what has guided you. So as a business person, read what's happening in your state, follow what you have to do, make sure you knock all of those things off, and then you can move forward.
And I think that's a great segue to the second point of what I wanted to chat about, which is it's the CYB, which is just cover your butt. So in this, and I agree with you that there's so much ambiguity and uncertainty about what's happening. And also, everything's changing every day. Like the legal issue right now of what I've been doing the past week, drafting nonstop, is not what I was doing 3 weeks ago, and it's not what I was doing 6 weeks ago. Like it seems like every 3 weeks something is happening. And just in that spirit of staying on top of it, because there's uncertainty, you want to try to protect yourself as best as possible. So I want to talk about waivers of liability that expressly relate to COVID. So normally the way that a waiver of liability works is someone is coming to either, now they're doing it online, which anyways, you are facilitating an experience for someone in yoga. So you're teaching them. It used to be only in studios. Now it's online and in studios. And soon it's going to be, sort of a hybrid of the two. In all of the amount of time that I've spent in drafting hundreds of waivers, and also in, being hired by, a claimant who's trying to attack a waiver, or being hired by a studio to defend a waiver, the same things always come up. And I'm happy to share with everyone sort of what the elements of a great waiver of liability are. And then I'm going to explain how that relates to the current issue of needing to cover your butt. So what every waiver of liability needs, it needs to specifically describe what activities you are doing with someone. It needs to describe what the risks of those activities are. It needs to describe what the outcomes of those risks are. Then someone has to, understanding the activities, the risks, and the outcomes of the risks, then someone needs to voluntarily participate and say, hey, I'm still choosing to participate voluntarily, understanding all of this. They have to give an affirmation of health to say, understanding, all of the risks and the activities, I'm healthy enough to participate. And then finally, they have to release you of liability. So in all of the research that I've done in preparing for settlements or any work around waivers of liability, the one theme that always emerges is that waivers of liability will not apply when they are not clearly drafted. And like clearly drafted is sort of unsatisfying to figure out why it doesn't work. But what they mean by not clearly drafted, they mean that either the activities were not expressed, were not described clearly enough, the risks were not described adequately enough, the outcomes of the risks were not described clearly enough. Affirmation, like it'll just be one, for me as a lawyer, that's what I'm always attacking. So I want to say, yes, my client did sign this agreement, but really the agreement wasn't clear enough that a reasonable person, would know that that's what they were getting themselves into. Does all that make sense?
It does.
Yeah. Does that make sense, Joe?
It does to me, yes, absolutely.
Okay, cool. So, and then we'll open it up to questions if anything comes in. But what's changed now is two things have changed. One is that everyone is now operating online, and the activities are now different than they were before. because the activity before was someone coming into your studio, or you going to someone's home, or you know, directly facilitating this yoga class, yoga teaching for someone. But now it's different because people are doing it online. So the activities are different, the risks are different, right? Like before, you know, you're in the classroom, you're walking around, you can see, you know, this crow pose is incorrect, or this downward dog doesn't work, or, I mean, Shavasana, I don't think you can really mess Shavasana up because you're just lying there and it's really delicious. But what I mean to say is the activities and the risks were different. So the first push of how everything changed was like, everyone's like, oh my God, I need an online waiver. Because also, like, now people, we can't supervise the space where people are practicing, right? And also, originally when this happened, we in terms of the affirmation of health, we wanted people to know that they were healthy enough without any COVID symptoms or whatnot. So the first big wave of changes that came through had to do with the online waiver. The second one is like, now everyone's opening back up, and in opening back up, you know, whatever, I can't comment anything about COVID symptoms or this, that, or the other, or, you know, probability of catching it. But now the activities are different and the risks are different because you're sharing a public space with other people who potentially have a communicable disease, which you can possibly catch. So the activities are different, the risks are different, and the affirmation of health has completely changed, because now from the affirmation of health, you want people to acknowledge in a document like, I've not traveled in 14 days, I'm not showing symptoms, I don't know anyone who has this, that, or the other. And now we've just seen like an additional need to update the documents, and just like to sort of like to close all of it out and then bring it to the point that you made. So what we've been doing a lot is getting, you know, yoga waivers out to clients as quickly as possible that include COVID provisions, because I can tell you it will happen somewhere that someone goes to a particular place and, you know, there's a duty of care to make sure that they're safe, and something happens and someone's gonna say, I got COVID at your store. It does not necessarily have to be yoga, but someone's going to. So what we're encouraging our clients to do is have waivers of liability that expressly relate to COVID and say, cool, we've communicated the activities, the risks, the outcomes, the voluntary participation, the affirmation of health, and the release of liability, and we build COVID into that. So in a, God forbid, a terrible, awful situation that something like this arises, we have documentation to say, like, we told you this was possible, and you still decided to come here, therefore we're not legally responsible for this.
Yeah, that makes complete sense. And just to add on one component, because it's a question that I'm sure that's on people's minds and it's come up several times, and that is, do liability policies, insurance policies, typically exclude or would typically cover the transmission of communicable diseases? And the answer is almost all liability policies, everyone that I've seen, has an exclusion for transmission of communicable diseases, which means that in almost any liability policy you buy, if you transmit the disease to somebody, the insurance will not cover it. So something to be completely mindful of. Our policy does have that exclusion. One thing that we learn is in a pandemic, it's very hard to find the source of a transmission. So the actual liability or the risk may be lower than most people think, because liability, that it has to be proven for it to be liable for a claim to kick in. But it's something I feel that people should be aware of, is that typically policies do not cover that. So a waiver becomes that much more important.
And I agree with you that, like, okay, if someone's going to get to that point of trying to pinpoint your particular studio, and this is like, that's a great segue also just to share that, like, we've also been working with studios on sort of like both a PR and a protocol backup of like what to do if you reopen and someone at your studio, like, come up with a plan before and understand exactly how you're going to communicate it. Do you then close for a certain amount of time and then clean it? And what is it like, what does it look like, and all of those things. But just to directly answer your point, the whole point of having the legal documentation in place is like, even if someone's alleging, like, they went to 4 places that day, they went to the botanical gardens, and then they went to the beach, and then they went to yoga, and then they went to Whole Foods. Firstly, that sounds like an amazing day. Like I would love that day for myself, specifically Whole Foods. But what I would want as lawyer for my clients is like someone, hey, someone's, has tested positive and they came to our studio, blah, blah, blah. Forward them a copy of the waiver. We're praying for you. We care about you so much. We want you to be okay. Please remember that you signed this agreement. And then it's like the buck stops there. So long, again, as we follow the rules and we're doing all of the other things that we have to be doing.
Absolutely. That makes complete sense. Cory, we have had some questions come in. I don't know if we wanted to maybe.
Yeah, let's just take one because I want to make sure we get through all of the 5 points.
Okay, great. So this is from an anonymous. How do you propose an online waiver for Instagram live classes?
That's a very, very common question. And it's very interesting because I have not found any particular cases where someone has got injured from watching someone on Instagram or on a YouTube channel, and then like, which totally, like a seminal case that ratifies how all of this has to be addressed. The way that I help my clients is coming up with a disclaimer. So that would be like a specific either YouTube or Instagram disclaimer, which you can put at the front, or in your bio, you'd want to link to your website. And then in the website, you will obviously want to have a privacy policy, terms and conditions, and a disclaimer. And like, that's the indirect way. But to answer the question, it's really challenging because it's very much one way. We're like, oh, I'm just doing this. And if so it could mean, before you practice, you say something like, hey guys, practice at your own risk. You're fully responsible for everything that you do. Don't go outside of your limits. If it's on YouTube, it's really easy because we have a YouTube disclaimer that we send to clients for them to use. But ultimately, you want to have a disclaimer on your website, and then you want something on your social media, if it's a link tree or something of the sort, to link back. I hope that was a satisfying answer.
And there's more questions, but we can wait till the end to get.
Okay, cool. And then we'll just keep going because I want to make sure that we chat about all of the checklist stuff. So another thing that I want to add, and this is specifically for everyone who has a team. One of the biggest issues we sort of saw emerging through this time was the question of an employee feeling that, okay, like what happens if I choose not to go in? And like someone may be filing a human rights complaint that I didn't feel like going in, but I went in because I didn't want to lose my job. And then I went in and then something happened and I never really wanted to. So in a really basic sense, in the same way that a waiver of liability has a provision about voluntary assumption of risk, for all of the employment agreements, we've been adding basically employee waivers, like only related to COVID. Because, obviously insurance, if they're teaching yoga at a studio and someone gets injured from yoga, like that clearly falls under what their insurance would cover. But what we've been revamping our employment agreements for, and this can be the same for contractors, if you've got contractors, it's just adding it's a release of liability related to COVID, but also putting something in that people are voluntarily choosing to come to work. Because my whole approach to law.
Fun.
Yeah, it still is fun, Joe. This is still fun. It's like, there's a lot of information, but it still is fun. The whole thing about law, it's communicating expectations openly and honestly. And by doing so, we'll have the best relationships we can possibly have. So I'm like a big proponent of design the ideal relationship that you have with the people who you work with. Let's put it in writing. Let's get them to sign it. If something comes up and there's a problem, we can always circle back to that document. And I could just foresee because, as an example, when all of this started, one of the issues that I was seeing a lot of was independent contractors writing me emails and saying, hey, I realized I was really an employee and, I want to file for unemployment, but technically I'm a contractor and what do I do? And like, it's a really uncertain time and the economy is not as strong as it was before all of this. So I could foresee there being some employment-like claims or something of the like. And as such, I think it's really important that we just have something in writing that employees are voluntarily returning to work. And it's just like, all it has to be is something as simple and basic as like, I'm choosing to come into work and I accept all relevant risks of doing so. And then plus having them sign sort of a COVID waiver. Is that clear?
Absolutely. That makes complete
Okay, cool. So then the next thing that I want to chat about is the importance of reevaluating your written agreements, and then also communicating what relationships you want. And this is, I'm going to share a particular area where I've seen a lot of this coming through, and maybe it resonates to you, maybe it doesn't. But we've seen, firstly, because everything has changed, you now have an opportunity to get people to re-sign things. So often people will say things like, oh, you know what, I really wanted to make the switch from contractor to employee, but I was too busy, or it didn't work, or this, that, or the other. But like now, as we reopen, it's like carte blanche to create any sort of relationship that you want, and include whatever provisions maybe you didn't have before, and have those in your current agreements. And the biggest issue that we saw had to do with cancellations of payments. So what was happening was two parties had a written agreement, and one of the parties would try to, the customer of the, let's say of a yoga studio, like in a really basic example, there's a yoga studio who has all of its members, and like everyone's canceling auto pay contracts, just like nonstop cancellation. What we saw was two things. One was that people were canceling outside of the original agreement they had. So let's say, and this is a case that I had, I'm not making this up. A client had a 45-day cancellation policy to say, hey, if you want to cancel your membership with us, you have to do so in with 45 days in advance, or cancellation will only be in effect 45 days from when you get this. On day two, the person was like, canceling right now. They go to the credit card company and they ask for a chargeback, and they say, hey, what, this, that, or the other, the services weren't provided, it's online, this, that, or the other. And then as a result, the credit card companies are then taking the money away from the studios, even though something different was agreed between the parties, right? Does that issue make sense, Joe?
It does.
So what we've been working on nonstop with our clients has been modifying their service agreements or their studio membership agreements to make sure they have all of the provisions in to safeguard as best as possible from all of these things happening. So one example would be like, and this is like, if the agreement doesn't have a force majeure clause, force majeure just basically means an act of God, and saying that like, okay, even if there's an act of God, the contract still applies and the terms still apply. And I have a client who's in the yoga industry who puts on a major event with like millions of dollars at stake. And the agreement did not have the appropriate force majeure clause, which like precluded us from a really easy avenue to get out of the whole particular problem. So force majeure clauses is one area where this is relevant and where this makes sense. Another has to do with the terminology around either using the terms auto pay or incremental payment, or what verbiage you have to use. And basically what we found in some of our research was that using the word incremental payment is acceptable by credit cards, whereas using something like auto pay is not, or recurring subscription is not. And like, look, to me, it's completely bizarre because both the credit cards and the banks are playing the role of adjudicator in these particular issues. And like, aside from my personal commentary of what I think is right, the important thing is like, okay, let's update our documents as best as possible to make sure that we're totally, that we're covered. So what we've been doing in advising about service agreements has been making sure that they are as strong as possible, so that if you get into a chargeback issue, you have an agreement that puts you in the best position to succeed. And like, just one other example that we've seen with our clients in relation to these agreements has to do with how the services are provided, right? So hands up if you're like, your services were always provided in person. Okay, I can't actually see anyone else, but yeah, Joe's were, so we've got one. But what happens is now what we've just been doing in the agreements in a really simple way has been changing it to say like, our services are now, the scope of our services will be either performed in person or will be performed online. And what that does is, the whole reason why refund policies get challenged, it comes from a policy perspective of the government saying like, hey, that's not fair. You're not allowed to take someone's money and not offer the services. But usually the threshold, like the litmus test is, are you still able to provide those services? So long as you can provide the services and like you're able to do so at a merchantable quality and blah, 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 all of these standards and things like that. But basically in plain English, like so long as you're still able to provide the services as per the agreement, they will not allow a refund that is outside the scope of the agreement. So even something as simple as changing the scope of what you're actually doing to include online, or, you know, even I was drafting something this morning where I expressly mentioned in the agreement, like in the event that we are shut down by the government, or in the event that we're shut down for some unforeseen reason, your membership will apply to everything online, and that will be that is included in the services that you're paying for. So what sort of just, if I can sort of summarize all of this and what I want to share is just that this is the time to reevaluate both the relationships that you have and think about how you can make them better, and what sort of systems do you want in place. You're the one who knows your business the best, but what can you fix about the current relationships that you have? Remember, so law is I said law, Joe didn't say fun.
Oh, sorry, I missed that.
Cool. It's okay. Law is a series of relationships, and in each of those relationships, you want to communicate openly and honestly. So this is the perfect time to reevaluate all of the different relationships that you have and think like, okay, how can this relationship be improved? How can I change the relationship with my clients? Okay, one thing is changing, you know, the scope of services to include online, or putting in a force majeure, or modifying refunds, or anything like that. Does all of that make sense?
Indeed.
Are there any questions on this point?
I'm sure some questions will pop up here. I know some questions have come in.
Okay, why don't we do this, Joe? I'll wrap it up, and I'll share my last point that I had, and then whatever the last 20 minutes or so, we can just go for questions.
Perfect.
Is that cool?
Perfect.
It's going to start raining here, so I'm just hopping inside. Thanks for everyone's patience with this. Okay, cool. So the last thing that I want to talk about has to do, and I think it sort of builds on the last point. So yeah, it actually, it's the same as the last point, more or less, but it's just the importance of understanding that this is the best opportunity that you have to get things in writing and to modify a relationship as desired. And then specifically what I was thinking of in this context was just the contractor employee distinction. So that's a really, really big area in law. And if you own a studio in California, you're at Best Legal Practices, which I hope you are, you've changed from contractors to employees. So in California, there's a piece of legislation that's called AB 5 that came into effect January 1, 2020, that said that anyone who performs a service, which is the core service of that business, at law is an employee. And if you try to categorize them as a contractor, then you will get fined, you'll have to pay taxes, you'll have to pay interest on taxes unpaid, and it can open you up to an audit, which sucks. Like if law is fun, audit sucks. Which, yeah. I've only been brought on after the audit, which I feel like that could be a Stephen King novel name, After the Audit. Ooh, okay. So what I want to say is the most important thing to know in the contractor employee distinction is that what will determine whether someone is a contractor or an employee is the degree of control you have over that person providing those services, right? So it's called the control test, and it's all about how the services are performed. Some of my favorite questions that I'll get from clients, or like favorite moments, so they'll be like, oh, blah, 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 but like this person's a contractor. I'll be like, okay, why is that person a contractor? And they're like, oh, like we just, felt like a contractor type day when we brought them on. And I'm like, okay, cool. I get that, how that works. But it's really important to understand that it's all about how the services are performed, and more specifically, how much control you have over the way that the services are performed. So specifically what I've seen happening now, and like, I'm part of why I want to share this is like, okay, these are the trends in the industry and this is what I see people going through. A lot of studios, were like consistently putting off the decision to change from contractors to employees, and during this period have decided to do so. And the reason why is that financially it could make more sense to have fewer employees but exercise more control over them than having like a whole big roster of contractors who you can't really, like, you can't control the way the contractors do the services. Like at law, a contractor lets you know, when they can come to do the work. You can't tell them how to do it. And like the standard example is to think of a plumber, right? So like a plumber, yes, they are coming into your studio to fix the toilet, but like they're using their equipment. They show up when they can according to their own schedule. You don't tell them how to fix it. They just know how to do it on their own. And they send you an invoice for the work that's done. And what's happening is for a lot of studios, now with everything that's changing, like they need to have more control over the way the services are provided. So as such, they're choosing to go with employees. And choose less employees, but have them have more responsibilities. And again, they're allowed to tell them exactly what they want to do. The other thing that I've seen is like a hybrid model where some of the teachers are just like straight contractors and like, okay, cool, you're a straight contractor. You submit when you can come into us, we'll fit you in the schedule in that regard. And we don't tell you how to teach your class. You come in, you teach, you leave. You don't have to clean the room after, none of those things. And then, so it's, the mix has been like people switching from contractors to employees, and then having less employees, having a hybrid system where they have both contractors and employees. And like, I think every client I've spoken to where we've gone through this, I don't think anyone has been like, oh, I'm just going to stay straight contractors, just because everyone knows it's coming. It's like the inevitability of a yoga studio or a yoga business only hiring contractors as teachers is really, really difficult. And I even had a client who like signed up for an independent contractor agreement. We drafted the agreement for her. I had a whole phone conversation with her explaining her how the services need to be different. And then she came back a week later and then ordered an employment agreement because she's like, it just makes sense to do so with employment. For me as a lawyer, I don't really care how you decide to run your business. What I care about is that you have the appropriate agreements in place, whatever you decide. And like, and the most important thing to know is that if you're in the employee zone, okay, the agreement is still important, like, the COVID release, like I mentioned, and also voluntary return to work, but also using the agreement as the opportunity to let people know what your expectations are in working together. And if someone's not reaching them, it's really, really easy for you to let them know what's not being done. But conversely, if you're like, okay, I'm gonna do the contractor employee thing, if your contractor agreement has like a whiff of employee stuff related to it, it can be a real challenge for you. And like, here's an example of how it's a challenge. One of my clients runs a studio. They had an issue with one of the teachers who was a contractor, needed to take a medical leave, like a medical leave of absence, and tried filing for governmental assistance. As a contractor, they weren't allowed to do so under the company. And then we got a demand letter where it was basically like, hey, here's a sample of the contractor agreement. In reading with this person's clearly, you clearly were treating me like an employee, but not paying me as such. And then we had to settle and pay out of pocket to resolve it. So just like it's a question that always comes up, and it's always evolving when the right time to move from employees to or contractors. And just like with all of the COVID stuff and needing to regulate more how services are performed, I've just seen it with a lot of clients coming up. Are you still, Joe, are you still awake?
No, I am, man. Thank you. No, I appreciate that. So, that very, very important information you're giving out there, and obviously information that's very well outside of our area expertise. So I really appreciate you, explaining all of that. The difference in contractor and employee is such a big thing in our industry currently.
Cool. I'm happy to take questions. From anyone who's got them. We've got 17 minutes left. This is Gringo. Gringo's here.
Perfect.
He
Hey,
wants to hear your questions as well. So anything you got?
let me throw a couple, because I had gone through as you were talking, I had answered some of the Q&A questions that came on, and when you answer them, they disappear. But there's a couple of them where I didn't answer them completely, so I want to make sure we address those since they are no longer written down.
Okay.
And so, for instance, one person wrote, and I don't really I don't know the full understanding of this question, but the question was, or actually it's right here. What do you advise if a client admits they have COVID already?
Considerations. My first question would be, in what capacity are you dealing with that client? So if everything is online and you're not seeing them and they're not coming close to you, like, right? Let's say I'm a yoga teacher and one of my clients has COVID and we're practicing online, I would just have a conversation to be like, are you sure you feel healthy enough to practice? I would probably modify it and have it maybe be more restorative than something, really Ashtanga based. But that my first question would be like, okay, in what capacity am I providing these services? Let's say there's someone who has, it seems like a no-brainer to me that I would ask them to wait, at the risk of the community, I would ask them to, wait until they've cleared and received confirmation from a doctor that they no longer have COVID before coming into the studio. And look, what I'd say for what I do say for everything, and what I would say for this as well, is that it always comes down to communication. It always comes down to either people being heard or you being heard, or making sure that you can address concerns that someone has. And look, you as yoga professionals, all of us have our own communities, and your priority is to make sure that your community is safe. So if someone has tested positive for COVID and then wants to come into the studio, I would say, I'm really sorry, for the health of the studio, we're going to ask to wait until we get, confirmation from you that you've been cleared and that you don't have it anymore. And then even if that happens, like, follow all of the protocols and maybe even have an additional protocol for someone who has tested as opposed to someone who hasn't. I hope that answers your question.
Thank you. All right, just going through these, super helpful. Can a contractor at more than one, this is from Anonymous, can a contractor at more than one studio be an employee at each of them, or will it have to be one? Okay,
firstly, I'm so sad that it's anonymous. It's so much more fun when you know people's names and where they're from, but that's okay. Feel free to post in the chat your name and where you're from. So the question is about contractors versus employees teaching at more than one place. The issue of what this falls under, it's like a super trendy topic in yoga, and that has to do with non-compete clauses. So firstly, in a non-compete clause, in some states they are enforceable, and in other states they're not. But the general thing before I get into non-compete, a much more clear answer to you is that it's all about how the services are provided. And like, can someone have two part-time jobs? The answer is yes. They can be a part-time employee at two places. They could even be a full-time employee at two places if they wanted to be. The restriction on it would be if either employment agreement says you're not allowed to, work at a competing business within a particular industry, in a particular jurisdictional zone for a particular period of time. The reason why governments don't love non-compete provisions is because it's a restriction on someone's ability to earn an income. So is it fair if you have a contractor who teaches 2 classes of yoga a week at your studio, and then you're trying to get them to sign a piece of paper that says, sorry, you're not allowed to teach anywhere else in a 7-mile radius? Like, they're working for you 8 hours a month. Why should you have the right to be able to say that? And alternatively, when you have a better chance to enforce a non-compete when it comes to an employment agreement as opposed to a contractor, just because, again, with contractors, the whole idea is that someone operates their own business. So you want to think of it as such. And like, if I operate my own business, why can I not have 2 separate clients? It doesn't really make sense. So I hope all of this is helpful and I'm answering the question. But another thing to add is, like, when it comes to non-competes, one of the issues where it can apply is like, you can't restrict someone's ability to teach yoga or perform that particular service, but normally a non-compete is enforceable if you're saying to someone like, you're not allowed to open a competing business in a particular jurisdictional range, like 2 miles, 3 miles in this particular town. And that's because that's an instance where like the government wants to protect you, who's a business owner. If you are a business owner, protect you and like the time and effort that you put in to build your business, and you bring someone on, you teach them how to do it. Like they shouldn't be allowed to go down the street and open up a studio and do the same thing. So I hope, like, I hope that answers the question, but a lot of people love getting fixated on non-competes or like, is someone a contractor if they teach it 2 or more, are they an employee? When it comes to the contractor employee distinction, just remember, it's all about how the services are performed. And it's either you're controlling the way the services are performed and they're an employee, or you have no control over how it's performed and they're a contractor.
Got it. There are a lot of questions coming in, by the way. We may not be able to get to all of them. If we don't, whichever questions we don't get to, by the way, we will review after this and then put out a message that addresses these questions. Just since we have so many coming in. Want to get through some of these chat questions too, because I know they were coming in all day. First one is, this is from Jennifer Warren. How often should a yoga instructor, this one looks like I can answer this one. How often should a yoga instructor expect to encounter some sort of claim against him or her, and how serious do the nature of the claims tend to be? In other words, just how worried should one be as an instructor?
Go for it, Joe.
Yeah, so the one good thing is claims are very rare. In fact, the vast majority of yoga instructors never have a claim filed against them. So that's a good thing. So it's not something periodic that typically occurs. Our claims we've seen come in anywhere. We've never seen anything north of a 6-figure claim, meaning a few $100,000, but they typically come in the 5-figure range, 10 to about $30,000 in general. But we have seen some even larger 6-figure claims. But the answer is they're very, very rare. In fact, there's 2 real types of liability that we cover. The first one being professional liability. That's what's really the light malpractice insurance. And the other one is the general liability. Now, general liability is what people call the slip and fall insurance. What's very interesting is that we get a lot more claims for general liability than we do professional liability. And what does that tell me? And to me, that means that instructors are doing good work. They're not hurting people. Professional liability claims would be if you were hurting somebody during the scope of the session, if you did something wrong. And we just get very few claims of that. We do tend to get a lot more claims of general liability, which is that slip and fall. You can't really foresee or prevent that freak accident that, there might be water on the floor, the person slips. Again, all of the claims are few and far between, but a lot fewer for professional liability, which again means that people are being trained well, and I think that's a good thing.
If I can just touch on that. Firstly, congratulations to us, for having not that many claims, which I love, and also just to understand from the legal perspective of it getting to the point of a claim being filed. It's like the first thing that my understanding is like the first thing that happens is not that a claim is filed. Usually there will be some sort of letter that is sent to a party. And then things will escalate to the point where someone's like, oh my God, like it's getting really, really bad. Now we need to go, file a claim and start this process and bring on the insurance and all of that. And then I just want to say that I'm normally involved in that, that first 15 to 20% of how things go. And again, the reason why I have this story at law, which is like my first day becoming a lawyer, my mentor took me aside and he's like, Cory, you're going to tell all of your clients one lesson. It's going to be pay me now or pay me later. And at some point, if you are operating a business, you are going to have to work with a lawyer and with insurance. So it applies to both of us and it makes sense for both of us. And you want to tell them like, it's better to have, stronger agreements at the start than not having any agreements or not having, downloading an agreement from the internet that you don't know or doesn't work for you. And then they're going to have to bring you on after the fact. Then it's going to cost way more money to them. And then the whole issue comes and then we get to the point of a claim being filed. So for me, the way that I want to see yoga professionals practicing is have the ducks in a row, set it up properly from the start. And then we're not even getting close to that claim phase because someone's going to send a demand letter. We're going to have a really awesome, clear agreement that says that, hey, sorry, you lose, you signed this. This is what it says. We're sending you our heart. We love you. We want everything to be okay for you, but you don't have a legal claim. And the buck stops there.
Got it. All right, I know we have about 7 minutes left, so I'll just get through what we can here. So this is from Ravi Bala. I hope I pronounced that right. I apologize if I didn't. Ravi, what clauses do we need to update in our online sites and do's and don'ts with new social distancing in our roles, as the studies are small and sometimes 6 feet distancing is a big challenge. So I think asking, is there any clauses they need to put in their online sites and their do's and don'ts?
I'm not sure what's meant by online sites. Maybe you mean the terms of service on your website, or maybe what you mean is like your service agreements that you have. But again, so I'm with you. The information is inconclusive. We don't really know what's going to be happening or what's right or what's wrong. But just the first point that I spoke about had to do with negligence, right? So how I would answer that question is that I would say, follow whatever the government is telling you that you should be doing, and put that into writing and have someone sign that. And what that does is, like, no one's looking to you and saying, hey, like, what's the perfect answer to how I should deal with COVID? If you're following what the government is doing, and someone's going to try to come back at you and claim that, whatever, you made an egregious error, or, whatever, this, that, or the other, and you can show that you were following what the government said, like, what more can we do, right? Like, that's the best. So to answer the question in terms of what clauses would I put in, I would follow the relevant rules of what the government is telling you to do to be at best practices. And I hope that helps.
Yeah, and to piggyback on that, I'm actually going to skip down 2 questions. So I want to make sure we do answer the questions in between, but I feel like the same answer is going to apply here. Meta Flows asked, can you offer a table of science-based facts on virus communicability on surfaces and guidelines for cleaning surfaces, in particular carpeting? Thank you. Use of masks affects breathing in yoga. Any advice on types of masks or safe practice where masks are not worn? Cory, I'll let you answer, but my first thought would be to log on to the CDC and follow as closely their guidelines, since we're all kind of working from that. But I'll let you answer.
Cool, you got it. I would link to a professional source. The one thing I would not do is try to answer that question if you do not have the qualifications to do so. Because that is the definition of negligence. If someone's asking you something that, like, there are serious implications to what the answer is going to be, and then you're giving an answer to something that you're not qualified to give an answer to, if I was a lawyer, I would just jump all over that. So defer, link to professional, link to professional, link to professional. That's it.
That makes complete sense. All right, so I can go back and make sure. So Karen Lutz had written here, and how many years do I need to retain a student's signed waiver after they have stopped attending yoga classes?
That's a tricky question. I would say just keep it. The way that it works at law is there's something called the statute of limitations, which means that you're allowed to bring a legal claim, and it varies on jurisdiction to jurisdiction, but usually it's like within 2 years of someone becoming aware that they had a reason to sue you, they have a 2-year window to bring an action against you. There are particular areas of law where that does not apply, but for what we're thinking of in our area, it would, let's say, roughly it would be 2 years. So that means, and the reason why they do it is at law, there's something called finality, where they don't want to let anyone just sue anyone whenever they wanted. Like for something that happened 10 years ago, there has to be closure and finality. What I would say is, like, keep it. If you have a basement, if you have somewhere, just keep the piece of paper, take a photo of it, put it on a Google Drive, whatever you need to do. But it would depend on your jurisdiction and the statute of limitations there, but you just always want to have that waiver sort of on demand when you need it.
Well, thank you. Well, we are kind of getting close here, and there are a lot of questions left. So what I'm going to do is, at the conclusion of this, we will, and it'll take us some time, we'll get these questions answered, and we'll find a way to link to them once we repost this. And then also I will give everybody an opportunity, or the contact information, that if you wanted to follow up with additional questions, whether they're for insurance or whether they're for Cory and his team, we can give you a link to be able to ask some additional questions, and ways that you can reach out to us and engage in business, if that would make sense as well. One thing I do want to mention at the conclusion here too is that everybody, you know, we've formed a great partnership with Conscious Counsel. That partnership is going to continue to come up with new and great ways that we can collaborate and offer great products and services and help to our clients. One thing we're doing for anybody involved or in and around Conscious Counsel Network is we're giving anybody a $10 discount on our liability insurance. Some additional benefits which you can get by going to beyogi.com/conscious counsel. And that's CONSCIOUSCOUNSEL, counsel spelled in the legal sense, counsel. But again, Cory, just really appreciate this dialogue. You know, it's very unique to be able to get a perspective of somebody so dialed into the industry, about somebody who has a law base and a passion for the industry. So just really appreciate you taking the time today, and look forward to doing potentially more of these and getting some more questions answered as they come up.
Yeah, Joe, it's a pleasure on all of us, and like I can, from the whole Conscious Counsel family, like, you know, to be with you guys and to be with B Yogi means a lot. And insurance is one of those areas where, you know, you just want to make sure you're working with the right provider and someone who cares and someone who understands the industry. So it's wonderful for us, and we're truly honored by it. And like, we're just getting started, man. Like the party started, the questions will come. I'm happy to make time for the B Yogi community always. And it's a privilege to share this information. So that's it.
Well, thank you, Cory. Thanks for everything. I look forward to doing more of these, and stay safe and healthy out there. And we'll look forward to the next time.
Okay, just lastly, was law fun for you today, Joe?
Law was fun today, Cory.
It is fun. This is law, fun. Perfect. Cool. Bye, guys. Thanks so much for having me.
All right. Thank you.
Ciao.